Good evening, my lovely people. I trust you are all doing very well. You are once again welcome to another tutorial with us. We are extremely grateful for taking time to watch this video. If this is the very first time that you are joining us, we would encourage you to subscribe to our page. We encourage you to like it, share it. If you have a comment for us, feel free. You can also search for us on Instagram and on Twitter. Not very active, but very active. You can find us on Instagram. We are very active there. Also on LinkedIn, you can find us there. Let's get in touch. Good. So today we are continuing our series, and we are talking about the concept of separation of powers. As I have tried to do lately, I would make the video very straightforward and simple as possible so that it is not very boring to follow. These concepts, for a very strange reason in class, appeared very quite boring and difficult to follow, but I will try not to do the same. So hopefully you won't find it very difficult to understand. But just in case you miss any of the points that we are trying to put across, just feel free in the comment section, just send us a message. We'll do very well to respond to that confusion that you have. Good, thank you very much. So now let's get into business. Good. So let me go back. So really we'll be looking at the introduction of separation of powers, some theories on separation of powers, John Locke, Montesquieu, what they had to say on separation of powers. We'll also look at separation of powers under the 1992 Constitution. Good. So when we talk about separation of powers, really we are just trying to understand how power is shared among the three main organs of government. Now, when I say the three main organs of government, I'm talking about the legislature. Now, when I talk about legislature, I'm talking about parliament. So parliament and all that encompasses it is the legislature. Then I talk about the executive. When I talk about the executive, I'm talking about the presidency, I'm talking about the ministers, I'm talking about the municipal assemblies, the district assemblies, the metropolitan assemblies. They all form part of the executive, the police, the armed forces, they all form part of the executive. Then I talk about the judiciary, and here I'm talking about our judges, High Court, Court of Appeal, Supreme Court, lower courts where I'm talking about the magistrates and or let me say our worship and then our honors in the lower courts and all other bodies that are around the judiciary. So what does the legislature do? So the legislature essentially make laws. Parliament, make laws for the country, and the executive, the main rule of the executive is to ensure order and to also ensure that the country is running smoothly. So we have the president, that is the commander in chief, making sure that the state is run smoothly, making sure that the day-to-day affairs of the company is done without any hitch. When he's supported by all these agencies of government, the metropolitan, the municipal, the district assemblies, they're all helping the president. All the other state agencies are helping. The police is helping, the army is helping, immigration, they are all helping just to run the state. So that is what the executive does. Then the judiciary, their role is to interpret laws that are made by the legislature and also to apply them. So they interpret and then they apply. Now, just from the onset, you would notice that there will be some sort of interdependency between these persons because legislature make the law, the executive is to enforce the law, and the judiciary is to interpret the law. So, assuming you got arrested for stealing banana, you'll be arrested by the executive. The police will arrest you. They will take you before the judiciary, a judge. A judge based on the criminal act you will be sentenced. That is, if you are found guilty, you will be sentenced based on an act passed by Parliament. Now, once you are sentenced, then a prison officer, part of the executive, would send you to Nsawam. So even from the onset, we see some level of interdependence between all the arms of government. But essentially, what we are saying here is that irrespective of the level of interdependency between these arms of government, it is very prudent and essential that these arms of government are separate and independent and doing what is expected of them, because it is very dangerous when you have the same persons running all these arms of government. Now, in such a case, we'll be talking about dictatorship, we'll be talking about autocracy and all the other, big names when it comes to one person running all the arms of the government. So separation of powers essentially is saying that all the three main arms of government must be different, and we shouldn't have one person manning all these three arms of government, or even two of same. Of course, as we go ahead, you will notice that there are in certain peculiar situations where you have, one person in two areas. But of course, we will see why that is the case. But the fundamental understanding or the baseline for separation of powers is that powers must be distributed among the three arms of government equally, so that one arm of government is not powerful than the other. Then again, let me interject myself and then say, even though the assumption is that all the three arms of government should be the same when it comes to power and authority and all that, you would agree with me that at times the executive seems to wield more sort of power and authority than the other arms of government. Of course, I mean, someone will say it is debatable, so I will leave it at that. But you can also, think about it and see if the point I'm making is legitimate or it is not. Good. So in the case of Youngstown Sheet and Tube versus Sawyer, so this is a U.S. case where I think it was in the Korean War, where the U.S. president at that time was Truman. And so what essentially happened was that the steel workers, wanted better working conditions or better salaries, I should say. So they wanted to go on strike. And because of the war that was ongoing at the time, the president didn't think it was prudent for, workers in the steel industry, because these steels were used in producing weapons for the war. So they didn't think it was prudent for them to go on strike. So what the government or what the president did was that he directed that, all these steel factories and companies should operate, even though the workers wanted to go on leave. And the steel companies challenged the authority of the president, to do that. And the whole idea was that the steel companies were privately owned businesses. And the assumption was that the president could not pass a directive forcing privately owned companies to open or to go back to work. And the decision of the Supreme Court of USA was that the president didn't have the power to force privately owned businesses to open, because they are privately owned businesses. I mean, they decide, what they want to do, and that it was only Parliament that had the power to make such a determination on privately owned businesses. So the holding was that we cannot, with faithfulness to our constitutional system, hold that the commander-in-chief, which is the president, has the power as such to take possession of private property in order to keep labor dispute from stopping production. So it goes on to say this is a job for the nation's lawmakers. So you see, the idea was that it was only the parliament that could make laws saying that privately owned businesses should be opened or not, but that the president didn't have the power to force employees in the steel industry that were owned by private individuals to go back to work. So here we see that the president was, stretching his arm into the arena of parliament, and the Supreme Court had to step in to say that the president could not do that. And these are some of the reasons why separation of powers is important, to prevent one arm of government from overly, doing what is expected of them, even though it would be in the interest of the state to have continued the war. The Supreme Court still believed that there was a better way around it, and not the president, forcing privately owned companies to open just so that weapons can be um, produced for the war. Good. I mean, this case is online, so you can always check it out and then read more about it. But that is it. That's the summary that I have provided. Good. Now let's talk about the theories, some of the theories on separation of powers, and a very common one that you would find is John Locke. So essentially, what John Locke was saying was that it was dangerous for for those in Parliament, that is, those who have the power to make laws, to also have the power to execute them. So he was of the view that those in Parliament should only be restricted in making laws. So those in Parliament should not have the power to also execute them. What this essentially means is that if those in Parliament making laws are aware that they are the same persons executing them, then it gives room for abuse. Then they can just, pass any laws and then just ensure that the laws are executed, how heinous or how arbitrary these laws may be. So John Locke was of the view that those that make the law should not be the same person that execute them. And he was saying that there should be some sort of differentiation between those who make the laws and then those who execute them. Good. So really, it goes on to say that normally when we look at separation of powers, we are looking at, differentiating the various bodies or arms of government and also assigning different, functions to them. So meaning that what the executive is doing should be different from what the legislature is doing and different from what the judiciary is doing. So we have two separate, or let me even put it right, that we have three separate arms of government with three different functions, meaning that one arm of government should not be doubling functions of another arm of government. So one arm of government should not be performing one function and also be performing the same function of that other government. So according to John Locke, if the various arms of government are different and the functions they are performing are also different, then we can say that there is separation of powers. Also note that separation of powers could also connote a situation where there is a differentiation in office and then the office holder, meaning that one person should not be holding office in two separate arms of government. Of course, when we look at our constitution and then the Ghanaian setting, we will notice that this example doesn't work for us, but for the foundation on which separation of powers was built, the idea was that an office holder should not be holding an office in the executive and also be holding an office in the legislature, because the assumption was that it could give room for abuse. So one person should not hold office in more than one arm of government, essentially. But you would agree that in Ghana, that position is different. And even the constitution enshrines that. But that is the foundation for which the concept of separation of powers was built. So essentially, all that I'm saying is that separation of powers is saying that powers must be distributed equally among the three arms of government. It continues to say that the three arms of government must be separate and different, meaning that we should have distinctively separate arms of government. So we should see the executive being different from the legislature, being different from the judiciary, and the function that these three arms of government perform must also be different. And we are also saying that the office holders in these three main arms of government must also be different. Essentially, that is what separation of powers, tries to say. I hope it is clear. Let's move on. So we can also talk about Montesquieu. So what Montesquieu also said is not too different from what John Locke said, except that for him, he did not make mention of the three arms of government. But I mean, the idea to him was that the legislative power and the executive power should not be placed in the hands of the same person. So the person that are making the laws and the person that are running the day-to-day activities of the state should not be the same person. Now, you would understand that for Montesquieu and the time that they postulated, these concept was a time where the judiciary was more like with the church. So you had the popes, and then the chancellors and whatnot, actually the ones providing justice or trying to resolve matters. So all matters were sent to the church, I should say the church. So for him, he saw two main arms of government, that is the executive and then the legislature, and not so much about the judiciary, because justice at that time, you could have a king, and the king who was the executive also had popes or cardinals or fathers or whatever name they were called back then, that were assisting the king, dispense justice at the time. So at that time, the judiciary, was not very distinct as we have now. So for him, he saw two main arms of government, and he was saying that these two main arms of government should not be placed in the hands of the same person, as it could be very, very dangerous. And I've already buttressed the points that one person should not be occupying two offices at two different arms of government. So that was the idea back then, because the assumption was that when that is done, it could be very dangerous. And we are talking about, and in times where we had the monarchs around, so they were just careful that if the monarchy, that is, of course, they were the executive at that time, if these same persons could also make laws, then you can imagine what would happen. And this was based on experience and examples that had happened at the time, where the king themselves were the same persons making the laws, which there were a lot of abuse, and a lot of dictatorship, and all that at that time. So for them, the idea was that the person making the law should not be the same person implementing it. Good. So now let's look at separation of powers and the 1992 Constitution. So with the foundation that I have already built, it would be a bit should I say confusing, but it would sound like in Ghana we don't have separation of powers. I think that's right. It would sound like that, because when you look at the 1992 Constitution, there seem to be a lot of situations where the Constitution is even encouraging that overlap between the three arms of government. And this is because the three arms of government are very interdependent. They relate to each other in their functions, and they can barely survive without the other arm of government. So there is this, checks and balances placed in the 1992 Constitution to ensure that these arms of government are doing what is expected of them. Good. So in Ghana, separation of powers is not absolute. Now, when I say it is not absolute, what I mean is that it is not a classical form of separation of powers where the three arms of government are different, and the office holders in these arms of government are also very different. No, that is not what we have in Ghana, because in Ghana there seem to be some oversight responsibilities over the main arms of government. So one arm of government is watching the other, and then the other arm of government is watching the other. So there's always. So in Article 88, well, for those that are aware, that provision provides that all civil matters against the state must be brought against the Attorney General. So the Attorney General is more like the state's lawyer. But in Amegache versus the state, the idea was that these arms of government are independent, and that they can sue and be sued. So the Attorney General could not, represent all the three arms of government, as it infringes on the whole idea of separation of powers, because you can't have the Attorney General representing the executive, the Attorney General representing the judiciary, and the Attorney General representing the legislature. Good. So when we look at some of the striking features of the separation of powers in Ghana, the first of it kind is that the various arms of government are captured under different chapters of the constitution. So you have chapter 8 dealing with the executive, you have chapter 10 and 11 dealing with legislature and then judiciary, respectively. So meaning that, yes, Ghana, I've already mentioned that the separation of powers under our law is not absolute, but of course, separation of power is very, very prominent in there. And the first is that there are various chapters of the constitution that deals or that covers the rules of the main three arms of government. Now, that's the first. Now, the second is that when you look at Article 58, that's Article 58 vests into the president the executive power. So more like the president is the head of the executive. When we look at the legislature, it would be the speaker, and then when we look at the judiciary, it would be the chief justice. Now then again, when we look at the legislature, that is the parliament, the legislative power is in parliament, and parliament is really headed by the speaker. And same final judicial power is in the judiciary, and the judiciary is headed by the chief justice. So you will notice that in these three main arms of government, they are headed by three separate different entities, and we know where their powers are coming from. So under the executive, the powers are coming from the president. Under the legislature, the powers are coming from the legislative body, which is managed or headed by the speaker, and under the judiciary, the powers are coming from the more like not necessarily. I mean, the judicial power is with the judiciary, but the judiciary is headed by the chief justice. So I'm all because it is the chief justice that directs how the judiciary is to function on the day-to-day basis. Of course, same applies with the president. These persons are assisted in what they do. But the point I'm trying to make is that these various arms of government are headed by three separate different entities, and their powers emanate from three separate entities. So you don't have the executive power coming from the legislature or the judiciary, no. And you don't have the executive power coming from parliament or the judiciary. They are all different. Good. Good. So then again, the position has been held that where executive powers are done within the confines of the law, there is no need for the courts, to come in. So meaning that if the executive, that is the president and its office and all the bodies under it, they do what is expected of them under the constitution, then there will be no need for another body coming in to interfere in what they are doing. Same applies to the legislature. Everything that is discussed in parliament is closed book. So the judiciary cannot go in interfering into the day-to-day activities of the legislature. The only interference that judiciary comes in is when a law is passed and it becomes public. But if it's something that is being debated in parliament, the judiciary has no business to go in there. Good. So another reflection of separation of powers in our constitution is the checks and balance, and I think I've already did mention that, which is that the various arms of government seems to check one another. An example is Article 59, where we notice that if the president is about to travel, the president would have to notify parliament. Oh yeah, I think I need to correct it. So the president cannot travel without first notifying parliament. And again, we see under Article 67, where the president is also required to give a presidential message to parliament every year. So State of the Nation address. So it means that every year the president is required to go to parliament and tell them what they have been up to. Then again, if the president is entering into, or the executive is entering into international agreement, it is required that such agreements are ratified by parliament. So if parliament does not ratify it, then it becomes a law. And there are a host of cases where, government entities entered into, certain contracts, and then they became judgment debts, and at the end of the day, it had to be determined whether these contracts were valid or not. And the validity or the otherwise was to be determined on whether they were ratified by parliament or not. And I'm sure you may be aware of this. And I'm sure there are a host of, such contracts that are already in court because of default by a government, and already, there always seems to be the final, cake, which is were they ratified by parliament. And I think now most international entities are very much aware of what the position is. So they try to do what is right before they enter into such agreements. But the position is that if it's an international agreement signed by the president, it must be ratified by parliament. Good. So for all the loans that the governments are going for, all such agreements requires parliamentary approval. That is why if the government is going to borrow, parliament must be informed, and for parliament to ratify before that can be done. So then again, the checks and balances even extends to appointment of ministers and all that. So even for judges, at least for those at the Supreme Court, yes, these judges must be vetted by parliament. So they must go to parliament, be asked a few questions. I think not too long ago, the current Chief Justice went to parliament to be vetted. So that also happens, and same applies to the ministers. The ministers all go to parliament for them to be vetted before they resume office. So same again, we also see the judiciary also having a role to determine whether certain acts done by the government are right or wrong. So the government can enter into certain acts, and then someone under Article 2, can go to the Supreme Court and then determine whether what the government did was right or wrong. So, and normally here you'll be praying for enforcement and an interpretation of the constitution. So if the government is doing something that contravenes or goes against the 1992 constitution, you have the right to go to court to check that. Now then again, you also have the right, under a judicial review, that is where either mandamus, quo warranto, certiorari, habeas corpus. We'll talk about all these concepts later. But where acts are done by state officials, and then they seem to go against you. So let's say for mandamus, let's say you are expected to be given an appointment letter or something from the state, and then the state is delaying on that. You can go to court for mandamus to force that public officer to do that habeas corpus. Let's say the police or the army has arrested someone, and then they are refusing to tell you where the person is. You can go for habeas corpus, and then a host of others. So the legislature is also checked by the court by striking down. The legislature is also checked by the court by striking down, legislations that go in contravention to the constitution. So I've already talked about that. So if parliament passes laws that go against the constitution, the courts have the rights to strike it down. So all these are checks and balances within the space of the three arms of government, and this is in the context of the 1992 constitution and how it enshrines the provisions of separation of powers. So then again, we also see the executive, more like checking the legislature, which is here. It is the executive that pays members of parliament. So it is the executive that would have to draw up a budget and then send to parliament for approval. But I mean, then again, the question is that if the budget for parliament sent by the executive is not very, juicy enough, the question is whether they won't, take against it. But of course, they try to rub each other's back, so they try to make sure that what is going to the other person is fair. But then again, that is how it is. So it is the executive that determines how much, or the emolument of members of parliament. Good. And also under Article 108, certain bills are only reserved to the executive. So it is only the executive that has the power to, send to parliament certain bill. Now, when I say a bill is more like um a law of a sort, but hasn't been approved as a law yet. So it is just a document containing all the provisions of the law. Now, once it goes through the parliamentary system, then it is assented to by the president, then it becomes a law. But before it becomes a law, it is a bill. So it's more like a quote unquote a law without the stamp of the president, and that is called a bill. And we are seeing that there are certain bills that only the executive can do. And if you see Article 108, you see what I'm talking about. Good. And I've already talked about Parliament checking the appointment of judges at the superior courts, and all that. So I won't even belabor that point. So I think I've already talked about all this. So again, I think it's a point that no need to repeat them again to bore you. I'm just saying that under the 1992 Constitution, there is a overlaps between the various arms of government. And then again, there's even the overlaps of persons, because you notice that under Article 78, it is saying that majority of ministers must be appointed among members of parliament. So under our constitution, it is saying that more of the ministers of the executive must come from parliament. And then again, if you look at Article 68, it also creates a situation where the speaker, who is the head of the legislature, assumes the head of the executive, and that is where the president and then the vice president are out of the country. Then you have the speaker of parliament assuming the role of the executive. So our constitution and then separation of powers, looks a bit doesn't go the classic form of separation of powers, which I have explained earlier. But I mean that is what we have. And the courts have on various occasions, explained that that does not violate the principles of separation of powers, which is that at the time that the speaker is the head, he is only the head for that particular moment, and can only perform, really very minimal certain tasks. So the fact that the president and then the vice president are out does not allow the speaker, to be making, passing certain executive instruments. No, no, no. It would just only be for that, brief period, and to perform very limited, ceremonial duties. So it's not as if at that material moment the speaker has taken over the entire, executive, and then can do whatever, he wants. So yes, on the face of it, it would look as if, it is infringing against the whole idea of separation of powers. But when you look at it, and then the roles that this person would perform in such a situation, they are very, very, limited. Good. Yes. So yes. So we have come to the end of this session. I hope I was able to explain it to the way that, it made sense to you, and also was very interesting. So if you enjoyed it, you can give us a thumbs up. You can subscribe. You can share with your friends, and if you have any question, just feel free and ask. So once again, thank you very, very much for watching this. I would have wanted to give a summary, but then again, I will just bore you with information that I have mentioned over and over again. So, yes, thank you and enjoy the rest of the day. Bye bye.